Hello, I'm Stephen Mather, a solicitor in Leicester acting for clients nationwide. I'm an expert in intellectual property law. Intellectual property, or IP, is the protection of things like copyright, the written word, trademarks, brands and logos, and patents, or inventions. If you own intellectual property, you've likely invested into your brand to the extent that you do not want other people copying you, or known as infringement. The vast majority of my work as an IP specialist is in relation to trademark infringement and passing off. And I'll cover both of these later in the video. I also deal with copyright infringement, as someone has used the words of your book, seminar, poem, song, and also infringement of design rights, whether those are registered or unregistered, and patent infringement, someone copying your invention. So what is trademark infringement? The Trademark Act 1994, along with case law, governs trademark law and trademark disputes. Section 14 of the Trademark Act deals with trademark infringement and allows for claims for damages, injunctions, and accounts of profits. Section 10 of the Trademark Act states what infringement of a trademark means. It can be using a registered trademark in an identical way, using an identical trademark to promote similar goods or services, using a similar trademark on identical goods, or using identical or similar marks in different classifications where the trademark has a reputation. So what's passing off? Passing off is where someone uses your brand or logo, whether it's registered trademark or not, and pretends to be your brand, or pretends to be connected to your brand, or as the case law says, sells on the coattails of your brand. In effect, they're jumping on your bandwagon. There is a three-stage test for passing off, which is 1. Goodwill. The infringed mark must have a reputation and goodwill. So does the public know or recognise your brand and link it to your business? There needs to be misrepresentation. The copying party must have confused the public to believe that their goods or services were yours or originated from your business. And thirdly, there needs to be damage. The infringed mark owner must have suffered damage and loss as a result of the actions of infringement. So why use me as an intellectual property disputes lawyer? Well, I'm a very experienced IP litigation solicitor. I've dealt with many disputes regarding all forms of IP. I'm one of few solicitors in Leicester to have a specialism in intellectual property. And that sees me instructed by companies and intellectual property owners throughout the Midlands. I can help in bringing or defending intellectual property claims. Many claims are dealt with in the Intellectual Property and Enterprise Court, IPEC. I can help you from start to finish. General steps in an intellectual property dispute might include sending a letter of claim, or cease and desist letters as Americans call them, agreeing undertakings with the infringer or the mark owner to stop future infringement, seeking an urgent injunction, and if necessary, issuing or defending a claim in court. Along the way, we'll also explore settlement, usually via mediation, and if that fails, then we'll prepare for trial. Hopefully I've covered some of the basics here, so if you want to know more, or would like to instruct me, then do get in touch. Please complete a form on the right hand side of every page, or give me a call on 0116 3667 900. Thanks for watching.